Hi guys, it's Kathy. I hope you're doing well. I hope you can hear me. So, the internet gods were not the greatest to me after I got off work last night and to now with content. But we're going to make do with what we have. I feel like I just pulled a feather off of me and I do not own a bird. I cannot have a bird in this house. That is one thing I will never be able to have is a bird or a mouse. There are zero mice in my house. I can promise you that. Not in the rafters, not anywhere. All right. So I don't even know where to begin. Oh, I forgot to do that one. Okay. Let's see. Let's think about this. Not really happy with any of them, guys. Really, I'm not. Let's start with you know what? Let's start with this. Hold on. I got one. Of course, I don't have one. I have the golden statue back. And we get to see the golden statue. No, we don't. Forget it. It's not here. I'm just gonna close my eyes and pick one.
Mr. Barrett and
Hold
Ms.
on.
Barrett, I took a closer look at the older case, the case where it was dismissed. And again, the exact same exhibits, everything is exactly the same that was in this other case. And Mr. Barrett, your remedy, if you disagreed with Judge Block's decision, you should have appealed her decision. You can't just refile another case.
I did write a new. I did do that. They told me that I did. I don't know if you can see it in the case. I went there and tried to get her to appeal it, and I also attached.
You had to file a petition for review. You may have written a letter.
I did. I went up to the. I did go to the county and file one. They said they don't know if she closed the case. I don't know if you can see the notes in there. I actually physically went there and requested and reopen it.
That's not the same as a petition for review, sir. So I don't know if you filed one. Great. So if you think it's not in the file. I don't know where.
And they told me they weren't. She probably would not reopen it. They told me to refile. That's the reason why I refiled.
No, Mr. Barrett, the reopening and appealing is not the same. She didn't refile it because she's got a final decision. You did not. Your remedy for that, if you disagreed with her decision, was to appeal. I'm not going to literally. This is exactly the same case you filed before. And you were ruled against. All of this stuff has been litigated.
Not figuratively, not theoretically, literally.
You wrote a letter. You have the right to appeal that, but it doesn't look like you actually did that. So I'm not going to relitigate this case tonight. You had the exact same case in front of Judge Block. It's exactly the same evidence.
She never looked at my paperwork. I'm giving you guys the physical deed. I have the deed. I have everything. I have all the proof.
You submitted all of that. And then again, she issued a final order stating that you admitted in court that you had transferred the property to your mom.
I didn't transfer. If I transfer it, you can log into the state website and see it. You have to file the paperwork with the state.
Mr. Barrett, she issued a final order and also stated that plaintiff needs to file an appeal if he does not agree with my decision.
And I went to the court. I gave them the physical. I even showed it to her that day.
You filed a letter, but you did not. I mean, it doesn't look like. I mean, if you did that, I mean, it's not a petition for review. If you want to try to file that, you can do that. It's late, but if you want to file. She's had a bench trial.
It's kind of early, Judge.
Your case on April 8th. Literally, I looked at all of it. Is exactly.
But I have the physical copy. Do Erica have a copy to show that I don't own the?
I'm not relitigating the case, sir. You've already had a full-blown hearing on this case.
What are we gonna do? Because I have proof that I own.
I think you need to talk to an attorney because you've already had a full-blown hearing on this. I'm not gonna have another full-blown hearing on the same matter where a judge made a decision. You had a remedy. I don't know. You filed a letter. I can see a letter. But then the Judge Block said you should file an appeal. I don't see a petition for.
We just got a letter. We just got a letter.
View in the file. I mean, maybe you e-file if you, I don't know, it's not in the file, but you know, if you want to file one, you can do that, but it is late, but you can try to do that if you'd
So
like.
I have another question, Your Honor. Erica signed the paperwork that she would pay me because she physically signed the
So,
paperwork.
Mr. Barrett, you've already had a hearing on this. The judge
Physically,
made a final decision. And
literally.
you can talk to an attorney at this point. I'm telling you, you need to file a petition for review. But I'm not going to relitigate a case that already had a full-blown hearing and it's res judicata. All of the issues have already been determined, sir.
Res
You don't get two bites
judicata,
at the apple. You don't
sir.
get
No,
two
what I'm
bites.
saying is there I have a physical deed. Do Erica
Mr.
have
Barrett,
the
you
deed? I
submitted
paid a mortgage on that house every year for the last 18 years.
Mr. Barrett,
I'm still
you've
paying the
already-
mortgage on that.
Mr. Barrett, I'm putting you on mute. You've already had a hearing on this case, a whole hearing where all of this came out and it was litigated and the judge made a final decision. If you disagree with that, you can appeal it. Okay, so I'm not relitigating the case tonight. I'm not doing it.
So
You had a
you're saying
full-blown
I need to
evidentiary
file,
hearing.
I need to file an appeal.
Okay, that's what Judge Block had already told you to do. It's not going to be timely, but you can give it a shot. But I'm not going to, you don't get another bite at the apple. You had a full-blown bench trial. The judge made a decision that you are not happy with, and your remedy for that would be to file a petition for review. And that's as far as I can go. Okay. All right. So that's going to be my decision. I'm just going to state that this case was already fully litigated in 25D-01788, and you guys are both free to go. Thank you.
So one more question. You said I can file a petition for review?
Yes, that would have what you should have filed. You can still file it, I guess, but
This is
it's
what they
not,
told me
it's
to in the
it's
courthouse.
untimely. All right, you're free to go, sir. Bye-bye.
Yeah, but was this case already litigated, Judge? You never answered that question. If it was already litigated or not. Okay, for this next one, I got it because new judge, new courtroom, new court angle. It's a tad difficult to hear him, but you get the gist of what you can hear him if you turn your volume way up. But you can hear the judge crystal clear, and the judge sort of fills in all the gaps that you're missing. Here we go.
Case number 24M2987.
And to everyone else, hold on behalf of Mr. Powers today, you're the person who speaking, right?
Mr. Powers, how you doing?
All right. So here's a little backstory so you understand what's going on. This box, where it looks like the camera is laying on the floor, kind of pointing up at the judge. That's the judge. He's just pro tem, though. He's not the normal judge, right? So he really doesn't want to do anything. He's not going to do anything. All right. Somewhere over here, we're going to hear some mumbling every once in a while from the prosecutor. He'll stand when he's talking. Okay. Right here is the defense attorney. For now, it's his defense attorney, sort of. He doesn't want her. I think the words that he uses, if you can hear it, is he wants to go and buy a professional attorney. I think that's what he says. He wants to go and buy a professional attorney. But we'll hear. I might have that wrong. I'm pretty close if I'm wrong. This is the guy. All right. Now, this is not the first hearing. This is, one of the middle ones as you go through a court case. And he was supposed to get a competency evaluation done. Yes, he was. But he has not gotten a competency evaluation done yet because no one can get a hold of him. But we're going to hear him talk. But what's really good, he's crazy, so he's going to say crazy stuff, and that's what crazy people do. But this guy right here, he's going to tell it to him straight. He's going to tell it to him exactly straight that what you're saying to me is not giving me any confidence that you're confident, sir. So here we go.
Thank you for being here and being so kind to wait. Ms. Stenholm, go ahead and update me on the status of the case. I'm looking at it anyway.
Yes, Your Honor, at this time, there has been a competency evaluation pending. It appears that, the hospital has filed a letter in the case saying that, they've just not been able to complete that competency evaluation.
Well, the problem is they can't reach him.
Yes, sir.
And I have the option of putting him in custody, so it's done then. And I'm sure no one wants that, nor am I interested in doing it. But do you have any updated information for you or Mr. Powers that we can get good contact information to the agency?
They do currently have a good contact.
How about this way? We just got a letter. We just got a letter. Just send him a letter.
Powers. I believe they may have a record to make, however, about the competency evaluation.
If you'll stand by, please file the contact information in the court file so that the evaluation office can access it.
Yes, sir. It's my understanding that it is the contact information.
Just please update it, even if it's the same thing. Okay, Mr. Powers, let me just give you a second here to look at your file.
First name
You're
Austin.
being represented by the Colorado State Public Defender's Office. The court continues that representation. It looks like back in January, Judge Williford, before he took his new position, ordered the evaluation to take place. Do you have any comment? You may proceed.
So with respect to, keeping contact with the, medical, physician,
I believe this is this guy speaking right now. I know the prosecutor is standing up, but I think he is speaking right now. So when I watched this through, it was a while, and then I thought, oh well, that's that guy. That's not the prosecutor. So I think this guy is starting his speech. And one moment, see if I can try to boost it anymore. I'm gonna put it as high as I can so we can try to hear him. But the judge will explain everything that he says. Don't worry.
I have been in contact with, on multiple, emails with them in the last month. And we explained the situation where, with respect to the previous public defender, there appears to be a conflict. And, the situation arose out of more of a whistleblowing situation where I, made fraud to, Mr. Haver,
So there appears to be a conflict with the public defender. There's not. That's just what he said. Then he said there was a whistleblower situation going on.
no fraud with respect to the Arapahoe County District Attorney's Office and the Public Defender's Office. After that, after I had the conversation with him, that's when the medical evaluation was being by Mr. Pepper and the judge that you referenced. I, in the last 2 or 3 months, going back and forth. I requested I relieve Mr. Pepper of his duties on a Wednesday night and like maybe together it. And the next session that we have, the court mandated that I keep it, despite, and I made a record of this.
So what he's saying is his attorney and the prosecutor are in cahoots, but the courts had mandated that he keep that attorney.
Of the record there is that I don't know the exact name Mr. Pepper went registered to be my attorney, and I think it's September of 2024. And I can tell you that the only conversation, the only email, the only letter, the only comments, discussions I've ever had with him have been in court. He's never contacted me. I've contacted him. I had to reach out to him to do this full contact I had with him, let's say November of last year. And he has been completely negligent in my opinion.
That's valid. That is a valid point that he just brought up, except for the fact that he said he had to reach out to his attorney. Well, dude, you're supposed to. They're not supposed to reach out to you. You're supposed to reach out to them. It's your case. But he said he's only ever had one phone call with his attorney. His attorney will not speak to him. So that's valid.
And that's why I relieved him of his duty.
So he relieved him
With
of his
respect to
duties. He
the,
didn't.
Medical evaluation. I've requested to see what the evaluation concerns were, Mr. Pepper. I asked the court, I think, the last few times about that, and I've not been able to have that. So I'm at this point seeking commercial or outside counsel so that there's not this conflict going on between the public defender and myself. And then I would need that information for my new counsel. And then the other thing is I would like to have all correspondence, anything that Mr. Pepper did do during his 9 months, 10 months as my counsel to be forwarded so that I could give that to my new counsel.
Anything else?
I just plan, one thing I am going to do when I leave here is I think the one issue that we have is the one conversation I had with him at the office for about an hour. And so I provided notes that meeting and I'm filing that with court so that if there's any questions going forward on what was discussed at that particular meeting, that the court will have.
Anything else?
So he did file. He's not the attorney on his case. But he did file some stuff with the court anyway. He filed a letter. I don't know what the letter says, but it pretty much probably says exactly what he just said, that he was a whistleblower. So they're all out to get him because of that. And there's a conflict with this attorney, even though there's no conflict. He doesn't get conflict counsel because there's no conflict. He might have a disagreement with his attorney, but that doesn't mean there's a conflict. And then he submitted notes that he wrote from the meeting with his attorney. He submitted those to the courts. And I don't know what they do with that stuff because he's not the attorney on his case, so he can't really file stuff. He's not allowed to file stuff. So what I think, and I don't know, hopefully Peg Leg will come in here at some point today, which he won't because he hasn't been here for a while. But what I think is the judge or the court has to keep that information with the case, but the judge is not allowed to look at it. Judge is only allowed to look at, motions and things that are filed by the attorney. So I do, however, think that the prosecutor is allowed to look at it. I really think the prosecutor can look at it. Judge is not allowed to look at it. And his poor attorney, I guess, is allowed to look at it. Now, his attorney, Mr. Pepper, isn't here today. This lady is here for him. And that could be because of a couple reasons. I think the reason, though, is that Mr. Pepper is his attorney in Arapahoe. And I can't remember off the top of my head which county this is, but I don't think it's Arapahoe. So Mr. Pepper works for Arapahoe in other cases. He has her or some other public defender in whatever county this is. I could be wrong, but I think I'm right.
Judge Williford ordered the competency evaluation on January 6th.
Sorry, this is Colorado. So competency evaluations don't take 6 months like they do in almost all other states. These guys got their mental health game on point. Now it's shaky. It's not always perfect, but it's the best I've seen so far. So he should have gotten that done months ago.
And I think you were here when that happened. Okay, all right. And I think what you're telling me is I've never seen the motion asking for the evaluation. Is that right?
I've never seen any evidence.
Okay.
Concerning any evidence supporting the reason for.
Thank you. So I'm a stranger to you, right? I am. Okay.
Stranger danger.
And I'm not going to be here probably won't be here the next time you come to court. I'm here to fill in, as a lot of other judges have filled in, for a vacancy in this division that will be resolved next week. Okay, so I
New
appreciate you
judge.
spending time with me, and you've waited, and you deserve it. Best explanation I can give, but I'm giving it to you from a not a very well connected position because I wasn't here in January. Okay, so what the process is that courts want to be very careful to make sure that people who are in front of us on a criminal case are able to assist their defense and assist their lawyer, that they don't suffer from some mental disability or condition that interferes with that. And I'm sure you appreciate that. You're faced with a charge, you're presumed innocent, you have an attorney needs to assist you on it, and we want to make sure that you're able to assist them. So Colorado's statutory framework, and I appreciate you allowing me to be a little simplistic about it because I think you could appreciate more complex explanation, but I don't have time to do that. Once one of the parties, whether it's a DA or a defense attorney, says, "Judge, there's an issue of competency, I'd like to have that addressed." Okay, so they filed that, and that's what Mr. Pepper did, but it says it's under seal. And so that means that it's kind of a secret to you, which is irritating and seems unfair. But that's how it was done. And then Judge Williford ordered the competency evaluation. At this point, I don't have the authority to change that order. So let me lay out the future for you. It may very well be bogus, but that's what the evaluation is designed to find out. When the evaluation is completed, depending upon its outcome, you're entitled to have a hearing on it. At that hearing, your attorney would assist you in challenging the evaluation. There may be another evaluation. If it determines you're competent, then it's over and we move on. At any rate, you don't want Mr. Pepper involved anymore, right? Okay, but you don't want him anymore. Are you still concerned with the public defender's office representing you?
At this point, I am, because the fraud that I've uncovered.
Thank you. Just yes or no. That's all. That's fine.
Yes.
So you are welcome to secure private counsel anytime you want to and discuss it with them. On the issue of whether we appoint an outside attorney, we have to wait for the evaluation to be done. We're really just on hold. Colorado requires us to be on hold.
Your Honor, with respect to the evaluation, I think it is defamatory and it is intended to, in terms of the process, without going into extreme details so that we don't have time for. I have been involved in significant investigation of fraud by the Colorado courts and the public defender's office and the prosecution of Rockland County. And so I believe this is a retaliatory and intentional.
I don't have any ill will towards you.
Sir, I've never met you before, so I like try to give the benefit of the doubt.
I have no ill will.
But with the information that I will be submitting to the court, it's a fraction of what I've developed over the last 4 years. And so they've explained it to me that no one's gonna give me the information. You've explained that it's sealed. and that no one
That's
can
not
use it.
exactly what I said. I said the motion seal.
Motion sealed. So
Okay,
I would need an attorney or myself to request that it be unsealed. That's what I'm understanding. You're
right.
saying.
I'm trying to pick out what it is. I think I know what you want. You want this company stuff stopped. And your concern is that this is improper action, retaliation by the DA and possibly the public defender's office. Okay, now I can appreciate, and I believe that that's your thought. You have to appreciate from my end that that may be an indication of your incompetency. From my end. And I'm not making a conclusion about it at all. Do you understand that? Okay, so here's your
We are judge. We've made our conclusion after he started talking. We've concluded.
options. I would first of all encourage you to complete the evaluation. I can tell you that I'm not going to do it, but the sitting judge coming in may order you to be held in custody to do it because that's an option. Not ordering you to, not telling you now about it, just telling you, okay, that's something they could do. Next, you are welcome to contact
Judges say, not my job, not my problem.
any attorney and hire you and hire them, and they can attack that order for evaluation. Don't think the public defender's office is going to do it because they filed it. Certainly the prosecutor's not going to do it because they're representing somebody else. So you can hire an attorney to do that. Now, the last thing is you said order the DA, order the PD to disclose their work product, right? The notes that they have about you. Okay. The court can do that with your new attorney.
But what is my process going forward?
I would
His imaginary new attorney. Maybe his imaginary new attorney can talk to the imaginary prosecutor and come up with a solution.
suggest they probably won't do that.
They won't turn it over.
No, because of it, because not only is there attorney-client privilege running to the client, but there's also privilege running to the attorney. Now you've given me all this stuff that I haven't had any time to prepare for. I'm just telling you where things could go and your options. But I'll reiterate, I don't have the authority at this moment to change the order of evaluation. And I encourage you to finish it up. And I suggest that it'll probably come out as competent. So you should finish it.
Then it becomes a part of my record. So, if I find out that my social media and right further,
All right.
5 years of probate in Rhode Island,
We'll order this record here sealed.
And here's where I come into play.
For pending now. If it gets out somewhere else, because you put it there, I can't help that.
I'm not putting anything out there.
Okay. So what we've done now is I've ordered this case to be sealed at this stage.
When you said the case, is it the everything related to the case or related to the
Competency. Okay.
Okay, but I would still like to know what Mr. Pepper has reported. I understand that you can unseal it, but the assurance of the profit is that only an attorney can do that?
Stand by. Defense position about unsealing the public defender's motion. Sure. Good luck.
I would just ask to make compliance with the competency evaluation condition of Mr. Power's bond.
Thank you.
This has been an ongoing process.
Thank you. Okay. Court appreciates that.
Your Honor,
Stand by. Stand by.
Yeah. Judge, on the.
Ms. Rendon for the public defender. Go ahead.
Thank you. On the matter of unsealing the motion raising competency, my understanding is that there are prohibitions in place about unsealing, but I would love the opportunity to reach out to a supervisor because if you do that, I would definitely like to do that for me. And also just like all parties to be aware that when a competency evaluation is returned from the evaluator, that is also correct. So that is not part of public record and would not be.
Yeah, that part kind of sucks, doesn't it? We never get to read the competency evaluations. Never.
Part of the record, so to speak, in that respect.
Stand by.
All right, guys, it's time to ponder. We all
So,
have to
Mr. Powers,
ponder.
one of the reasons for sealing is so the DA doesn't know the defendant's counsel's concern. Do you understand that?
Yeah.
Okay, so that's one of the reasons for sealings. Another reason for sealing is that it doesn't go out on the public line. No one can access it. I'm not convinced that sealing is to shield you from knowing. It's more designed to seal it from adverse parties to you.
I appreciate it.
So,
My ceiling shields me my upstairs floor.
if you'll let me do this, the public defender who filed this, they have to make sure that they're not violating any ethical standards by saying their position on sealing. I'm going to do this. I'm going to do we have a good mailing address for you?
1330 South Corona Street.
Okay. I'm going to allow them the opportunity through Tuesday to let us know about that now that I've spoken about what I thought. And you have any time on Tuesday? Are you here in the afternoons on Tuesday? I didn't think so.
Sometimes just I will be in work.
Mr. Powers, how about you on Tuesday afternoon? Can you come back? So I'm gonna hold on that request to unseal. Have the public defender's office make a position to me for a hearing on Tuesday, and then I'll make a decision. But you're still ordered to cooperate with the evaluation. The DA says make that a condition of bond. I'm not going to do that now because I don't think it's necessary, but I'm going to look at it again on Tuesday.
Thank you, sir. I understand the process. Thank you for explaining it. The reason why I wanted the information.
I accept that you need it and you're entitled to it. Okay, and we'll leave it at that. I dispute that. We're entitled to it. I'm not going to have a hearing about it now because I've just decided to hold off deciding it with my understanding that it shouldn't be kept from you. There's not something so terrible in there that you shouldn't know about it, and it's your case. It is designed to prevent the DA from knowing about it. So if we release it, we'll have to excuse the DA or make sure he doesn't have a copy or make a decision whether he gets one. You understand that? Oh, it's absolutely necessary because
Never make me a judge. Yeah, never make me a judge. It depends what mood I'm in. Either everybody, including the prosecutor, not the defense attorney, but everybody, including the prosecutor, are going to jail. Or just the defense attorney is going to jail and everybody else is going free. That's just, and all the people in the gallery, they're going right to jail.
you know, the things that are in there might be used by them on cross-examination if you take the stand on your trial. Oh yeah, he's not your lawyer through the public defender's office. Yeah, but this man still is. He's still with the public defender, but the DA is still here. They'll take notes of everything that happens. What time can I do? It's going to be a crowded day, Mr. Powers. You may be waiting, but I appreciate your attendance. 1:30 on Tuesday. the 10th of June, right here with me.
Thank you.
Hopefully, thank you.
Second and split.
If you'd like. And I need to always remind people when they come to court that you remain on your surety bond. Remember that? Okay.
No, I have a better idea. I know what I would do if I were a judge. I would just enter it all into AI and tell them to decide. ChatGTP, are they guilty or are they not guilty? How many years?
And all of the orders about don't harass, threaten, or retaliate, you will of course continue to follow. And I encourage you and direct you to respond to at least set up something with the evaluator. Whether you need to go through it or not, we'll address again on Tuesday.
Yeah, my whole point on that is look at the information and I talk to my attorney, I'll let him. Or him or her evaluate that.
We'll address that on Tuesday. Thank you.
Bobby, too savage. That's too savage. That's just rude.
Okay,
Thank you.
take care.
All right.
I don't think I'll have
Let's just go to Eric. Hi, Eric.
Yeah. Is 1 o'clock good for a break or? Yeah, we'll take our break at 1.
Okay. I think this is the one where I got like just a little bit of him just I don't know. In one of these clips, and I don't know if I even have it today, he's just like playing around at the beginning, and it's awesome. I don't know if this is it or not.
Council.
When the court's
Yes.
ready, we have number 23, Mr. Garcia Olguin. Great, thank you.
I'm sorry, this is?
Number 23, Mr. Garcia Olguin.
All right, 25 CR 2196, People versus Garcia Holguin, entries.
Tom Walton for the people. And Ben Britton on behalf of Mr. Garcia Olguin, who appears in person in custody at the podium with me to my left.
All right, set for arraignment today. What do we want to do today?
Yes, Your Honor. My notes indicate that at the preliminary hearing date, the people were put on notice to address bond. We do wish to address bond, and then I would be asking for a brief set over of the arraignment.
So no need to appoint a public defender.
I believe that was on the record previously. Belt and suspenders, though, I suppose wouldn't hurt. Let me just double check.
Come on, boys. You got to pick up the pace a little bit, please. I mean, I know this isn't a race.
All right,
but
I don't see an appointment in what's been filed after the bind over, so I would request the court appoint the public defender's office. Garcia Olguin.
All right, PD appointed. Put the DA on notice, but I guess I wasn't on notice, so.
All right, Judge, it's not that deep. Oh, yeah, it is. Look, he's asleep. He's asleep. Oh, he's not. I paused it.
Great, thank you.
There we go. Yo, same.
I'm sorry, this is?
Number 23, Mr. Garcia Olguin.
I don't remember this clip. I wonder if I grabbed this by
All
accident.
right, 25 CR 2196, People versus Garcia Holguin, entries.
Tom Walton for the people. And Ben Britton on behalf of Mr. Garcia Holguin, who appears in person in custody at the podium with me to my left.
Reviewed the facts of 22 CR 43.
We're here talking, I was talking in the last.
Huh?
Last sentence had.
This is the one. This is the one.
Hell, they could take 100. Yeah, all right. I'm sorry, Mr. Black, did you have someone else you want me to call? Or was that it, Detweiler?
That was Detweiler, yeah.
Okay. Get the courtroom camera on.
There it is. Guys, the gold statue's back today. Well, this was not today. This was like 3 days ago? 2 days ago? But they turned the camera back to the gold man. I love this judge. Don't worry, I stop it. I stop it, and I put the court back on in a second. I'm just watching them set up the camera.
Docket. First chance. What happened here? Looks like there may have been an FTA in county.
The comments
Already had a
you
show
make,
cause hearing.
I'm 100% sure the comments you make on videos also counts towards experience points.
And judgment enters on the bond back in May. So it looks like we'll need to set bond and set an arraignment. Anything else?
Your Honor, I believe that we need to set this matter into 1H. I believe Mr. Moses has some cases there already. And I'm checking the.
Okay, this is
no.
why I got this one. Okay. So they're talking about moving Mr. Moses to 1H. So if I do my job right, we should be seeing him in the future because 1H is Susan Blanco. So they want to put him in the mental health docket with her. And I've been trying to get her mental health docket. It's on Thursdays when she does it. So it's not every single Thursday. But when she does the mental health docket, it's always on Thursday afternoon. So you're probably always going to see her Fridays or Saturdays if she's streaming on Thursday and if I get it. So we're going to watch. Okay. The judge is struggling right here, right now, in this picture, because the prosecutor said, or the defense attorney, I don't know, said that they should move this to 1H. And the judge doesn't want to do that. The judge does not want to move this anywhere else. He just doesn't. He doesn't like that at all. So he has to think about this hard before he decides to do it.
Numbers on that.
But if he does do it,
As far as bond, Your Honor, we would be
we'll get it because I'll get her docket.
reserving bond argument at this time, trying to determine what's going on in 1H.
Your Honor, if I may, it appears that they need to do an evaluation on Mr. Moses.
What are the other case numbers?
Looks like 21 CR 183.
All right. I do see that competency has been raised in 21 CR 183. That matter is set. Well, is set in 1H, but he failed to appear in April. Failed to appear in March. February.
Blanca's gonna get him. Yes, she is. Remember that one judge we had that kept them locked up as long as they were absconded? So if you missed 3 months, guess what?
Wow. So back in November of 24, it was sent down to that 1H docket. Court ordered the full evaluation.
I feel like I saw him before. I think it might have been in 1H, but I'm not sure. But I feel like I saw Mr. Moses before.
All right. Well, but
Come on, Judge. Are you going to give it to 1H or keep it? We need to know.
the full eval was ordered, and then he's failed to appear ever since. He was deemed incompetent as a report was filed February 6th of 2025, and then he's been failing to appear ever since.
Who deemed him incompetent? Did he have an evaluation done, or did a judge do it?
The 21 CR 183 is set for appearance on warrant on the 17th in front of Judge Arnold's. Interesting question is we send things to 1H for the pre-screening. pre-screening's already been passed. You ordered the full screen. He's not competent.
And I might be able to,
Is it more logical that the 1H case is then going to get sent back up to Judge?
This is him trying to keep the case. This is him trying to keep the case right where it is.
Myers in 5H. So
I can provide some context, Your Honor. My understanding is that what it seems like ages ago, we had a doctor performing screenings in 1H. That has not been the case for some time now. And so unless someone is presenting in such a way that Judge Arnold is able to make the preliminary finding of incompetency herself based on that's the only instance in which a full order is not being, or a full evaluation is not being ordered at the pre-screening stage.
okay. God bless it. All right. Well, today I'm going to enter. Well, let's help out 1H, I guess. I'm also going to call 21 CR 183 people versus Moses just as a help to 1H. It looks like on January 7th, 2025, Judge Arnold's, the defendant actually appeared in custody. He was on bond in the 21 CR 183 matter, and he was being held on the new case, the 25 CR 122. The court ordered an evaluation for competency, and the mental health stay entered. Pardon me. After that January 7th date, the defendant failed to appear on February 25th, 25, March 11th, 25, April 8th, 2025, June 11th of 2025. And in the meantime, a competency evaluation was provided to the court on February 6th, 2025. That evaluation found that Mr. Moses does have a mental disability or developmental disability that prevents him to consult with his attorney, and they issued an opinion that Mr. Moses is incompetent to proceed. So in 21 CR 183, I will order restoration. In the 25 CR 1662, we will use the eval that was filed in 21 CR 183. We will also enter a mental health hold. Enter the finding of not competent.
This ain't right, guys. I just found something bad. This is not right. Now, remember this, what I'm about to show you is 3 years ago. This was 2022. Whoops, that's not what I want to show you. Judge Eric Johnson's 2022 evaluation. So they evaluated him. All right. Good news is he meets performance standards. Bad news. By a vote of 7-2. I want to know who those two commissioners were. One of them was absent. There's always one absent. I don't know why. But he did not meet the court's benchmark for completing 90% of his cases within 12 months. Just so you know, he goes through 100 cases on his docket, 90 to 100 cases on his docket. His dockets are the longest. Well, him and Cristofino, remember Cristofino in Indiana, his dockets are real long. So 57 attorneys, 44 non-attorneys. For the attorneys, he has a 50% of the attorneys and 93% of the non-attorneys believe that he met performance standards. That means 50% of the attorneys says that he doesn't meet it. His combined attorney and non-attorney survey scores are below average in all categories. He received many negative comments. So he responded to this feedback with self-reflection. Now, tell me something. Who believes that? Everybody. He pondered. He pondered that, guys. He pondered. That's just bull. He's awesome. He's amazing. And it says that that the surveys are listed below, but there is no survey. Hold on. Ooh, look what I found. I don't need no table of contents. Overall grade, 3. All district judges, 3.4. He has a B score. Hey, listen, B is way better than I did in school. So, Judge Johnson, hold on. Blue means yes. Okay, this is Judge Johnson's score. It's right here. This is all district judges. What is this? Oh, never mind. I'm not going to point that out. This is also Judge Johnson. And this is all district judges. Oh, so this is what the attorneys rate him as. The non-attorneys are very, very, way more fair and just. They gave him a 93%. It's the damn attorneys that hurt him. Case management, not, this is all, and this is the judge. Application and knowledge of law. Are you blanking me? Communications. All he does is communicate. Diligence. He takes an hour on every case. I don't like this. This is bad. I want to see the next one. I want to see a better one. I want to see a different one. This is bull. This is just, you know what? This is propaganda. This is fake news. I'm sorry to show you fake news like that.
And also order restoration. The charges in the 25 CR 1662 are vehicular eluding. I'm sorry.
I wonder
No,
if in 2022 he didn't ponder. What do you think?
I misspoke. Thank you.
Come on, Judge, get to the end. Please. Hi, Zach.
right, so it's a palpo charge. All right, so in 25 CR 122, using the evaluation from 21 CR 183, entering the mental health hold, enter the finding of non-competent in order restoration. The other case is set for appearance on warrant in the 21 CR 183. I won't take any action as to the appearance on warrant. We'll let Judge Arnold's deal with that. And on 25 CR 122, we'll also set it in 1H on the 17th for the same date and time to keep the cases together. And I'm going to enter a bond of a $1,000 surety bond.
This is bizarre world and everything is backwards. I don't understand. So, you know that very calm spoken judge we see, with the mental health cases, right? They have her as a 2.4% fairness because she's too harsh. They have her is too harsh. And they have this guy who is very harsh as it's backwards, it's reversed. For her, the attorneys all scored her great, but the non-attorneys 50%, just like it's backwards from this guy. I don't know what's going on.
On the 25 CR 122. Anything else from the prosecution?
No, Your Honor.
Defense?
No, Your Honor.
I'd buy a Model T. I would in a heartbeat.
Yes. I don't think we need to do the screening and all that because, yeah, we're just following the progress of the other case. And yeah, we've already got we are entering the order for restoration in both cases. Would Judge Arnold's do anything differently?
I don't believe so, no.
All right, sir. Judge Arnold's, we'll see you just in about 4 days.
He was almost giddy this whole case.
And then
All right, let's just go to Maricopa. I didn't watch
On this
this.
calendar. If I said a security appearance bond for you, you
Hopefully
go
it's
to a
good.
bonding company. The names and numbers are on some walls in the jail. If you can't find one, ask one of the officers for assistance. I'm not going to recite out loud all your release conditions, but they'll be on your paperwork, so it'll be your responsibility to read them. All right. At a minimum, they'll say no drugs without a valid prescription and don't drive without a valid driver's license. If you're here on a probation violation, there'll be a requirement. You need to contact your probation officer within 72. Please start your name and date of birth, please.
Robert Stumbs, 7/14/1999.
Okay. So you're here in two matters, both probation violation matters. It's like you're on probation for possession, drug paraphernalia, in both. You're alleged to violate terms 3 and 5. Appointing a lawyer for you. Your court dates will be June 20th at 8:30 at 201 West Jefferson. Like I mentioned, contact your probation officer within 72 hours of any release. No alcohol, no weapons, no drugs without a valid prescription. Another judge said bond for you on each one of $400. So your total bond is $800 security appearance bond. But if you post your bond, make sure you show up and contact your probation officer. All right, step to your left, please. It's down 13 or 14. I didn't realize he was on top. I don't know what happened. Okay. And John Watkins is on deck. Francisco Leppi? On deck, John Watkins.
Commissioner, you're going to use this all the way through the call.
That's what happened.
Yeah.
Okay. Thank you. I was wondering. All right, so your name and date of birth, please.
May 22, 1982.
What?
May 22, 1982.
But it's Francisco, I pronounced it.
Francisco Lepe.
Lepe, okay. All right, sir, you are charged with a domestic violence charge of criminal trespass in the first degree. In regard to this, I'm appointing a lawyer for you. Your next court date will be in Superior Court. Excuse me, just double check one thing. Is on June 30th at 8:30 at 175 West Mass Street for status conference. You'll have a witness preliminary hearing on July 2nd at 8:30. State was recommending a $1,500 bond, but I've decided to release you to pretrial services. So you'll be getting out in about four hours, but you've got to contact them to get the paperwork because you have to be in compliance with their regulations to stay out of jail. Okay?
Yeah.
Make sure you make your court dates. He'll give you the paperwork. What's actually due next is Juanita Rodriguez with Desmond Ortiz on deck.
Sure.
All right, your name and date of birth, please.
Juanita Rodriguez, March 2nd, 1967.
All right, you are charged with criminal trespass in the first degree, a class 6 felony. I'm appointing a lawyer for you. You're not to return to the scene of the alleged crime or have any contact with the alleged victim or complainant or witness, rather. You'll be at 175 West Madison Street at 8:30 for a status conference on June 19th. Witness preliminary hearing is June 23rd at 8:30. Now, I do find probable cause you committed this offense. I would also note that you are out on release in CR 2025-000086, and your initial appearance was on or about June 14th of this year. And so pursuant to Rule 7.2, you will be held without bond at this time. Now, you can have a evidentiary hearing on June 20th at 1:30 at 175 West Madison to determine where the bond can be set. Your lawyer will explain that to you. At this point, there'll be no bond. All right, step to your left, please. Desmond Ortiz with Justin Derosset on deck. All right, sir, your name and date of birth.
Desmond Ortiz, 5376.
Okay, one thing, sir, I know you got your arm in sling advantage. If you want to rest on the podium, leave.
Guys, does Victoria work in Maricopa County too? Look at this guy. Victoria, for the love of God, stop beating them all up. Let them go.
Forward, that's fine with me. Because that'll make you more comfortable.
No, it's
I know, I'm saying whatever you need.
Okay.
I'm not going to think it's disrespectful.
okay.
Okay,
Thank you.
that's what I'm trying to say. All right. Okay, so let's start with your name and date of birth. I'm sorry.
Desmond Ortiz, 5376.
Okay, sir. You are charged with 1 count of aggravated assault, a class 3 felony, 3 counts of possession of weapon by a prohibited person, class 4 felony, 1 count of aggravated assault. I just want to double check one thing here.
He got in trouble for assault. It looks like he got his ass beat. And he's in jail for assault. Judge, this ain't right.
Sir, the reason I did some checking on that, because you're charged with 3 counts of possession of a weapon by prohibited person. In terms of this, I've got to I got to make a change in this because I only see mention about one weapon, so I'm only finding probable cause as to one of the three prohibited possessor charges. Okay, so it doesn't mean you won't be charged with it, but just based on the limited information I have, I only find it for one, in addition to the other charges. Sir, also, at this point, I do not find that you're eligible for a court-appointed attorney. You're going to try to hire your own attorney. If you find you cannot afford one, then you can ask your assigned judge and see whether he or she would grant that request, but no promises in regard to that.
Okay.
Okay, I want to mention that to you. The state is asking for a $75,000 bond. The court dates will be at 175 West Madison for a status conference on June 19th at 8:30 and a witness preliminary hearing on June 23rd.
Just so you know, he was charged with multiple counts. That means he had weapons. He had more than one weapon. And this is what happened to him.
8:30. You're not to possess it. You're not to initiate contact with the alleged victim or victims. Not to possess any weapons. All right.
I bet you it was a cat. I bet you he got drunk and tried to fight a cat with some weapons.
If you are able to post your bond, you'll have to, before you release, you'd have to have an ankle bracelet put on you with a curfew with hours. You'd be able to leave limited to hours approved by pretrial services. Bond is set in a cash bond of $50,000. Step to your left, please. Justin Darrasset with Juan Romero on deck. Your name and date of birth, please.
Justin
Hi, Bill.
Durosset,
I'm sorry.
12/22/1975, date of birth.
Okay, sir. All right, sir, you are charged with aggravated assault, class 4 felony, assault, and disorderly conduct, class 1 misdemeanor, all domestic violence charges. Now, according to pretrial services, you wanted to hire your own lawyer. So sometimes, when people say they want to do it, but they can't afford it. So I'm appointing a lawyer for you right now. It doesn't prevent you from hiring your own attorney, okay? But I'm saying this way, you have an attorney, okay? And I'll tell you this, I have a victim statement which I have reviewed. And the state has made a recommendation in regard to this also, all right? And they're recommending a $50,000 cash bond. Okay, first of all,
Everybody in here is getting a $50,000 cash bond. That's insane.
you're not to return to the scene of the alleged crime, initiate contact with the alleged victims, no alcohol. You may return to the scene of the alleged crime one time with a police officer on a civil standby to pick up your personal effects. I'm not going to set a cash bond. And for you, it'll be a security appearance bond of $50,000, so you can go to a bondsman. All right, so step to the left, please. Juan Romero with Jacob Interpreter on deck.
I missed that. What kind of interpreter? I missed it. It's fine. We'll figure it out.
All right, so your name and date of birth, please.
Juan Romero, 04/18/2004.
Okay, sir. You are charged with aggravated assault with a deadly weapon, theft, and threatening and intimidating. We have a victim statement that I've reviewed.
$50,000 bond, maybe?
I did appoint a lawyer for you. You'll have your status conference on June 19th at 8:30, 175 West Madison Street, and a witness preliminary hearing on June 23rd at 8:30. You're not to initiate contact with the alleged victim, no weapons. The state is asking for a $50,000 security appearance bond. I'm going to make it a $20,000 security appearance bond, but if you post your bond, you have to wear an ankle monitor with a curfew. You can only leave your home during hours approved by pretrial services.
He said 50,000, didn't he?
Jacob Interpreter with Jason Walden on deck.
Oh, I missed it again. I don't know what type of interpreter.
Okay. Sir, your name and date of birth, please. Jacob Interpreter.
Oh, that's his name. They weren't asking for an interpreter. His name is Jacob Interpreter. Okay, you got to remember, in this courtroom, these people have just gotten arrested within the last couple hours. So frequently I've seen that they're still blasted, they're still drunk, they're still high. Which I think might be the case with the interpreter here.
4372. Okay, sir, you wouldn't know about the charge because this was a grand jury indictment. Okay, so, and it's charging you with 2 counts of aggravated DUI based on being a third DUI within a certain period of time, a class 4 felony. I am appointing a lawyer for you. You'll have your original arraignment on June 20th at 8:30 at 175 West Madison Street. Okay.
I can't get that
consume
one.
the alcohol, no drugs without a valid prescription. Now, another judge has already ruled on this upon the return of the indictment and made certain findings. It's a cash bond of $10,000, and you'll be under supervision of pretrial services with both alcohol and drug testing and monitoring. So if you post the bond, you'll have to get in contact with pretrial.
So the guy who had the weapons charge, 50,000. Everybody had a $50,000 bond. This guy's got his third DUI. It was indicted by the grand jury or whatever. $10,000 bond.
Services. There should be a packet that you'll be getting from the officer. All right. Step to your left, please. Jason Walden with Jeffrey Scartosi next on deck. So your name and date of birth, please.
Jason Lafayette Walden, September 26, 1969.
69, okay. All right, sir, you're charged with burglary in second degree, class 3 felony, and 2 counts of aggravated assault, a class 6 felony.
Those
I'm appointing a lawyer for you. You'll be at 175 West Madison Street for a status conference on June 19th at 8:30 and a witness preliminary hearing on June 23rd at 8:30. You're not to return to the scene of the alleged crime. You can't not to initiate contact with either of the alleged victims. You must contact. Hold on 1 second here. Oh yeah, you must contact your case manager within 24 hours of release from custody because you know who your case manager is. Okay. Also, you must obey terms of any orders of against harassment issued or will be issued. The state is asking for a $25,000 security appearance bond. I'm going to reduce it to $5,000 security appearance bond. So make sure you show up, do all the things you're supposed to do, like I mentioned. And, all right? So if you post your bond and make sure you make it to court. All right, step to your left, please.
On the 19th?
What?
On the 19th?
19th and the 23rd.
Okay.
It'll be on your paperwork, by the way.
All right.
So don't lose that. All right.
Oh, yes, sir.
Jeffrey Scartosi with Isaac Forrester on deck. All right, so your name and date of birth, please.
Jeffrey Joseph Scartosi, 131 and 81.
All right, sir. You are also had a grand jury indictment against you, so that's why you wouldn't know about it. That's why you wouldn't know about it necessarily.
Okay.
I guess got to lean forward so people have to lean forward so people can hear me with the microphone. So I'll lean forward here. They're charging you with 2 counts of theft of means of transportation, class 3 felonies, and 1 count of burglary in the 3rd degree, a class 4 felony. I am appointing a lawyer for you. Your not guilty arraignment will be at 175 West Madison Street in 6 days or 5.5 days on June 20th at 8:30 in the morning. You're not to initiate contact with the alleged victims.
Okay.
Okay, and another judge at the return of the indictment set bond for you in the amount of a security appearance bond of $3,000. So you can go to a bond thing.
Okay, so what's my bond? Like 3,000 or?
3,000, yeah.
Okay.
And you can't go through a bondsman.
Okay.
Okay, good. Step to your left, please. Isaac Forrester with Isaiah Reese on deck. All right, sir, your name and date of birth, please.
Isaac J. Forrester, May 293.
Oh, you don't have to lean down. I should be able to hear you, okay? All right, sir, you got two matters before me, both probation violations. I'm appointing a lawyer for you on both. All right. On both of them, you're alleged to have violated terms 3 and 5. Are you
Nah. He's not still drunk. No way. This is how he is.
You're on probation for both of them for possession of drug paraphernalia. If you get out, contact your probation officer within 72 hours of release. You can't possess or consume any alcohol, can't possess any weapons, and you can't use any drugs without any valid prescription. This in regard to both of them. Now, in regard to CR 2023-10251-0, another judge has set bond for you in the amount of $1,800. And the other one, which is CR 2023-118768, as I said, the alleged to violate terms 2 and 3. The other judge set bond for you in the amount of $750 with the same other release conditions. So this $2,550 security appearance bond to get out. All right? All right, step to your left, please. Isaiah Reese with Jonathan Amaro Castillo on deck. All right, sir, your name and date of birth, please.
There's Reese, February 1st, 2003.
Okay. Okay, so you are charged with aggravated assault and resisting arrest, and I'm appointing a lawyer for you. You also will be at 175 West Madison Street at 8:30 for a status conference on June 19th, and a witness preliminary hearing 4 days later on June 23rd at the same time.
Juneteenth.
Right? You cannot return to the scene of alleged crime. You cannot initiate contact with alleged victim or victims. All right? The state wanted a bond of $5,000. I've reduced it to $1,500 as a security appearance bond, so you can go to a bond.
Wow,
But make
judge
sure you
is
make
so
it to court.
nice.
All right? Step to your left, please.
$1,500 bond.
Jonathan Amaro Castillo with David Tendler on deck.
What happened? I didn't hear you.
Oh, I'm sorry. You got here quickly. Yeah.
My name and my date of birth. And
Yeah.
good evening to you too.
Okay.
My name is Jonathan Amaro Castillo.
And your mother's last name was Castillo?
Yeah, my mother's last name is Castillo too.
Okay.
And my date of birth is September 27, 2004.
Okay. All right, sir. You were charged with aggravated assault on an officer. No, actually, let me look at this for a second. Just to remind myself of it. It's a bench warrant, but I got to double check something here. Yeah.
So are you able to hear me? Were you able to hear me?
I can hear you.
Okay. I just wanted to make sure.
Oh, no, if I could, I'd let you know. Okay.
You got it.
That goes both ways. See, what happened, sir, you got a bench warrant, you didn't show up for the arraignment on May 31st of last year. And it looks like, the reason I'm saying, you looks like you were indicted by a grand jury. And before that, they went to the grand, you'd been released earlier than that, but then they indicted you instead of a preliminary hearing, looks like, okay?
Okay.
So, your arraignment will be June 20th at 8:30.
Okay.
At 175 West Madison Street. And I appointed a lawyer for you already. You're not to initiate contact with the alleged victim. Now, your judge set bond in the amount of $1,200. Now, you can go to a bondsman on that, by the way.
Okay.
Okay?
Thank you very much.
David Tendler with Jared Schultz on deck. Sir, your name and date of birth, please.
David Tendler, August 26, 2003.
All right, sir. You are charged with aggravated assault with a deadly weapon, dangerous instrument, a class 3 felony. I'm appointing a lawyer for you. Your court dates will also be at 175 West Madison Street on June 19th at 8:30. Witness preliminary hearing on June 23rd at 8:30. You're not to initiate contact with the alleged victim or victims. You're not to possess any weapons. The state was recommending a bond of $50,000 on your case. Sir, I'm going to make it $5,000. You can go to a bondsman. Be smart, go to court. All right? So if you post bond, better be there, or else I'm sure there'll be a much higher bond. All right, step to your left, please. Jared Schultz with Roberto Valenzuela on deck.
You want to see him for an address?
What?
You want to see him for an
Oh, sure. Do you want to see his picture, or do you have a picture there? Do you want to see his picture, or do you already have it?
I already have it.
Okay. Because I think it's that gentleman that you tried contacting. It's hard to tell without the face. You see what I'm talking about?
Yeah.
Oh, jeez. But all right. So you are charged with 1 count of aggravated assault, class 6 felony, and 3 counts of assault, class 1 misdemeanors. I'm appointing a lawyer for you. You'll have your status conference on June 19th at 8:30. Witness preliminary hearing on June 23rd at 8:30, both at 175 West Madison Street. You're not to return to the scene of the alleged crime. You're not to initiate contact with the original victim or victims. You're not to consume any alcohol. You can return 1 time to the scene of the alleged crime with a police officer on a civil standby to pick up your personal effects. All right? Now, the state wanted a bond. I would tell you the amount of $25,000 cash. I'm setting bond. I'm taking a chance of just a security appearance bond of $500. Okay? It's considerably different. All right? But you better show up for court and no contact with them. You understand that?
I understand.
All right.
Oh, sugar. I wonder if his eye accidentally hit that other guy's cast and they wanted a $25,000 bond and he got a $500 bond. That is a huge difference. I wonder why.
A security appearance bond of $500. Okay? It's considerably different. All right? But you better show up for court and no contact with them. You understand that?
I understand.
All right. Step to your left. Charles Toma with Jackie McFarland on that deck.
Good evening,
Sir,
Your Honor.
your name and date of birth, please. Your name and date of birth.
Oh, yes. My name is Charles Toma, 10/19/1964.
Okay, sir, you're here on a bench warrant, basically on a probation violation. You already had your arraignment on that. You already have an attorney on this. So you're going to have a non-witness preliminary hearing, non-witness violation hearing on June 20th at 8:30 at 201 West Jefferson. Likewise with other probation folks, if you get out, contact your probation officer within 72 hours. No possession or consumption of any alcohol, no weapons, no drugs without a valid prescription. Your judge said bond in the amount of $500, security appearance bond, so you can go to a bondsman.
Yes, sir.
Yeah.
Can I say something to the court, please?
Well, okay, sure, but I must tell you, everything's being recorded.
Yes,
I generally recommend to people not to talk because the lawyers can get upset
I was told to present that to the court. Because last time when I was in court, you, gave me 90 days.
I didn't.
Well, the judge, gave me 90 days in jail, and he said that he would recommend for me to go to rehab. So what I did, I got released. I went to the ARC, I went to the rehab in Tucson. I completed that rehab. I got my certificate. While I was in the rehab, I got a
While you're
letter.
talking about it, I'm looking at your probation officer's notes, by the way.
Excuse me?
I'm looking at your probation officer's notes at the same time.
I'm just saying that, I went to court surprise, and I thought that my warrant was out of there. So they gave me a court date for June 23rd in surprise. So when I approached the officer this morning, I didn't think I had a warrant. I willingly went and talked to him and asked him.
Let me explain something to you.
The only thing I'm asking.
Let me just tell you, there's a note I'm looking at. Back in April, they noticed you completed your detox and we're currently in a 28 residential program. Okay. I have limited information, sir. All I can do is go by the warrant. So what you can do, you'll talk to your lawyer about this, try to straighten it out. Okay.
But I got to go to outpatient.
I know. I'm just telling you, that's something your lawyer will have to work for you on. All right.
I don't have no money to bail out, sir.
Okay. Well, you can try to contact.
Please give me a warrant.
You can contact that office and see if someone could work on it sooner rather than later. Okay?
What office?
Step to your left, please. Jackie McFarland with Jared Lee.
No, not Jackie McFarland. We're going to end. Okay. For the most part, this stream is over. I want to play like 4 minutes of another clip. But it is definitely going to tick some people off because the audio is awful. The audio is awful. So, no, people, they didn't show up to court here. This is not people showing. These people were arrested in the last few hours. They were arrested. They made it. I read that. They plucked them right off the street in whatever they were wearing when they were on the street. So this whole place is freezing and everybody in Arizona is like not dressed because it's hot in Arizona. So they're in there freezing. But no, they didn't decide. Who knows? It's probably what they're going to wear anyway. But for this one, they didn't do it on purpose. All right. Now, I'm going to end this by spending 4 minutes in another courtroom with bad audio. But I love her. I just love her. Nothing crazy happens. I just want to show her for 4 minutes, and then I'm going to end the stream. Or 6 minutes.
But you also, I guess, in the felony case, you went up to felony court already? You haven't found it? Or was this a felony that they tried to indict it? I don't know what.
It was a felony that was reduced or refiled as a misdemeanor.
Okay, so that's what it was. So there is no felony.
Yeah.
Well, apparently, they're still not getting it right, because I just got an email that is there a dismissal next year? Okay, so it's just administrative, that apparently something was not correct in the filing of the paperwork for this case. I just got the email, I don't know what it is. So there's a dismissal on my queue, but don't get excited because they're saying they're gonna refile it. So you may have to come back to work. Come back here next week. Okay, I don't know when they're gonna do it, but I hate that for you. It's just, I just got
Thank you,
notice
Jude. Thank
that
you.
something's wrong, something happened in the DA's office. And so we'll sign the dismissal, but I strongly suggest you just kind of check and see where things are in the next week or so. See if there is a progression on, okay? Okay. So you can go. Thank you. Sorry about all the confusion. I don't know why I apologize.
Listen to what this next attorney says, if you can understand him.
Yeah. Right? Okay. So, let me go ahead and sign it. You can read it all.
She's running.
Matthew Johnson, case dismissed.
She's running for re-election in 2026. Yes. I love those
Yes.
glasses. I love them. The next attorney coming up is saying something like, you know, I missed your inspirational quote. So she has her own social media going on. That is not, it's not her as a judge. It is her social media. And she was posting, you know, inspirational quotes in the morning to start the day. She hasn't lately. She's slowed down her social media a bit. She's gonna get back to it. She just got a little busy. It's she just put another one out not too long ago. So the attorney comes like, I missed your inspirational quote this morning, Judge. Hi, Crystal. What a brown noser. That's what I would say too.
Yeah. Okay, Counselor, come on up.
Good morning, Judge. I'm here on Lanella Hayes. And you rescheduled this so we could get the PTI in place. There's been a couple of issues that we were in the middle of resolving. My client didn't have a driver's license. She's paid everything up, but it's not showing that she's eligible. I think she might need to file an SR-22, but I'm going to get her to do that today. Anyway, long story short is if I can just have a little bit, she's been approved, everything's in place. We're just trying to work out her driver's license issues so we can.
Okay, you can get one more disposition center.
Thank you so much.
You're welcome.
I thought I had to grovel more.
No. All right, the ones that grovel on the third and fourth disposition. Thank you.
Yeah, pretty sure.
Yes.
Good morning, Judge.
In
Next
4
one is,
minutes.
missed our quote of the day.
You missed, what?
Our quote of the
I didn't
day.
do it today.
I know,
I
I was
know, I'm
like,
training, I'm rushing, I'm trying to get down.
I was waiting for it.
Thank you.
Yes, no. Judge, I have Mr. Molina.
Mr. Molina.
Yes, and, I'm not, they offered a PTI class dismissal. I can just have one way set for him to do that.
So it's just another dismissal. That's fine. I just wanted to show her for a few minutes. Nothing crazy happened that I got. I didn't get her whole docket because the audio is just so bad. She's working on it though. She keeps texting me saying she's going to get new equipment. She hasn't yet. All right. That's it. That's all I got. It should pop you right over to OJ. Thank you so much for coming out. I wish I had better. I wish the internet gods would have given me something better, but I had very little time. It's so hard because I closed Friday, open Saturday, closed Saturday, and then 4 hours later, this is my stream. And nothing, I can't record anything because there's no courts on Saturday-ish. There's some, I just don't get them. I will see you all tomorrow with way better stuff. I'm sure of it. You guys behave today, okay? Behave. I want to see you all again real soon. And if anybody was doing the opposite of a parade yesterday, I support you and thank you. Bye, guys. Simple. My next stream is right now, Jude. It's going to pop you right over to it. It's OJ Simpson. Bye, guys.
Got these life echoes, digital dreams. Through the screen, her blue eyes gleam. Wicked humor, sharp as a knife. Her stream sparks electric light. Late night when the world sleeps, she's the friend that always keeps. Giggles roll like thunder loud. She stands out in any crowd. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no alarm. Dreaming tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle, she lights the way. Her eyes near a sky so blue. In her jokes, there's a truth so true. With each stream, she brings the light. Turns dark days into bright. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no alarm. Streaming tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle, she lights the way. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no